Hello, welcome to the Law Professor channel. In this presentation, we'll be looking at tort liability for negligent misstatements. Tort liability for negligent misstatements. And this presentation addresses the question whether there can be liability in the law of tort for negligent statements that cause pure economic loss. Negligent statements that cause pure economic loss as opposed to statements that cause personal injuries or property damage or economic loss that are a result of property damage, for instance. So we are examining the narrow view of negligent misstatements that cause pure economic loss. And I would, as usual, share my screen. My screen. I enjoin you to subscribe to this channel where we hope to bring you presentations on relevant areas of law for your understanding, either as a law student or as a practitioner who wants to further their legal education, continuing legal education, so to say. So please subscribe to this channel, and it promises to be very educative and informative. Now, negligence misstatements that cause pure economic loss. What is the position of the law of tort? What is the position of the law of tort regarding negligent misstatements? Traditionally, tort law did not recognize a duty of care, did not recognize a duty of care for negligent statements. It did not recognize it. And the only form of liability for statements was the one that was premised on other areas of law and other aspects of the law of tort, but not for negligent statements. So in today's video, we shall be considering the premise for liability in tort for negligent misstatements that cause pure economic loss. Our learning outcomes in this video are as follows: to understand the nature of negligent misstatements in tort, to determine how duty of care is formulated for negligent misstatement, to understand the reluctance of courts to allow liability for negligent misstatement, and to understand the basis of liability for negligent misstatement in the law of torts. In the law of tort, we would consider the types of liability for statements, and then look at the evolution of liability for negligent misstatements before going through to examine negligent misstatements liability and the various components that can be found in our learning outcomes. Now, types of statements. Statements that are made where there is a contractual relationship. And when we say statements could be oral or written. They could be oral or written, can be a conversation. It can also be written, a document that has been prepared by someone, maybe an advice, accounting statements, insurance statements, any kind of document could represent statements in this context. The law only recognized liability for negligent statements that arise out of contract, where there is a contractual relationship between the parties. It also recognized liability for statements where there is a fiduciary relationship. For instance, a relationship between a lawyer and the client, or for statements that are deceitful in tort. Statements that are deceitful in tort. So where the statement is not negligent but was fraudulent, for instance, there was liability for the tort of deceit. The tort of deceit. But where the statement was negligent and it caused pure economic loss, there was no liability in torts. There was no liability in torts. And the case of Dairy and Pig recognized that deceit as a cause of action where for fraudulent statements. The inquiry in this presentation focuses, like I said earlier, on negligent misstatement that cause pure economic loss. And for that, tort law did not recognize a duty of care. And because there was no duty of care, there was no liability in the tort of negligence. For example, in Chandler and Crane, where financial statements, accounting statements were prepared for the chairman of a company for his exclusive use, for his use. And those who subsequently acquired the company decided to rely on the content of that statement in conducting their businesses, and they suffered loss because the statement was negligently prepared. The court held that there was no liability because it caused pure economic loss. And in that case, Lord Denning actually, in his dissenting judgment, tried to recognize a duty of care for statements that are negligent and cause pure economic loss. In the context of this field of study, therefore, we can say and recognize the fact that historically there is no and there was no liability for negligence misstatements. In fact, in Eskel and Continental Express Limited, it was said that negligent misstatement can never give rise to a cause of action in tort. Can never. Of course, we will know as the presentation goes on that this has ceased to be the case. The courts only recognize for liability, negligent misstatement that cause personal injury or that arise out of a fraud. If it causes personal injury, for instance, in Sharp against Sharp and Clayton against Woodman and Sons Limited, cases where because of the advice of, for instance, an architect regarding the construction of a building, which now collapsed and caused personal injury to the claimant, they were able to claim for personal injury, But if it was pure economic loss that arose out of that, they would not have been able to claim. For instance, where the building collapsed, that would have been a proper head of claim in tort, because that is an economic loss, no doubt. But that economic loss is consequence upon a property damage. That is a recoverable head of damage in the law of tort, because it arises from the fact that there is physical damage to property. But for instance, however, if that building that collapses, if there was already a contract to use it for a performance over the weekend and the building collapses, for instance, on a Monday, the inability to meet the needs of that contract is a pure economic loss for which they would have been unable to claim a remedy. The law held that there was no duty of care in most of these cases for not to cause pure economic loss. And the reasons, if we apply the test that we had formulated under the case of Dodogo and Stevenson, the test of reasonable foreseeability, we would ordinarily wonder why there should be no liability. But in such cases that we are considering and we'll be looking at, where it is personal injury that arises from a negligent misstatement, reasonable foreseeability might be enough, but where it is pure economic loss, it might not be enough. And other tests have come into play. Now, when we say pure economic loss, therefore, I want us to note that we are talking of pure economic loss that stands on its own, that is not premised or consequential upon property damage, like the example that I gave earlier. If you have suffered personal injury, for instance, maybe in an accident, and the person suffers injury to the person, to their body, or loss of their property in the course of the accident, or clothes are damaged, their vehicle is damaged, it's still a financial loss because the cost of those properties and the injury, probably you have to treat your injury and spend some money These are recognizable injuries in law, which you can always recover for. And economic loss that arises from those injuries are consequential upon damage to their property or personal injury. But where the economic loss stands alone, it would be impossible to claim. A good example of pure, identifying this cause of inquiry, pure economic loss, can be found in the case of Spartan Steel and Alloys Limited. The whole essence of that litigation concerned a situation in which the defendants had, by their actions that were considered negligent, damaged some cables in the location where the factory of the plaintiff was located. And because of the damage, power supply to that area, to the building, to the factory, was cut off. And the products, the goods that they were manufacturing at the point that the power supply was taken away were damaged. So they sued, asking for damages for the loss of the goods that were in production when the power outage occurred. They also claimed for profits that they would have made on those goods that were damaged. And then they also claimed for loss of profit for those goods that they could not make because of the damage. The court held that there could be liability for the goods that were in production and for the profit that they lost for not being able to sell those goods. But at the third head of liability, claiming that you want a remedy for inability to perform subsequent contracts, like for instance, producing other goods, was a pure economic loss for which there was no remedy. So that gives us an insight into what we mean by pure economic loss. Loss, financial loss that does not have any foundations in property damage or personal injuries. Now, what is the reason for the reluctance of the courts to recognize a cause of action, a duty of care, to be specific, a duty of care, not to cause not to make negligent misstatements that cause pure economic loss? It's the typical floodgate argument. For instance, Cardozo J said that you are trying to avoid liability in an indeterminate amount for an indeterminate time to an indeterminate number. And an illustration is a situation where there's general power outage and everyone is able to sue for the financial loss that they incurred because of the power outage. You can imagine how many numbers of people, you will not be able to determine the number of claims. Everybody in society will probably have a claim who are affected by that outage. And then you also have an indeterminate time for the claims. It could go on and on and on and on. And you'll not be able to put an end to litigation, wasting the resources of the court and the time of the court. Then you will not even be able to account for the number of cases. So the floodgate argument is also an argument against imposing a duty of care for statements that cause pure economic loss. Then the danger of imaginary claims that economic loss or financial loss sometimes may be fabricated. You may not actually be sure if those laws are real or they were imaginary. So another thing is that financial loss is speculative. You could only, for example, in the example that I gave you, inability to perform the contract that you would ordinarily have been able to perform if there was light. You have to speculate how many, for instance, opportunities they would have had in the time interval when there was power outage to their factory. So it is a speculative head of injury. The reasons were also noted in Byrne and Hedley Partners that negligent words, when you speak, for instance, in the information age that we are in, everyone is speaking. We are speaking and we are speaking and we are speaking. We speak in the brick and mortar world. We also speak in the world of the internet. Everyone is posting a video, is making statements on YouTube, they are making statements on Facebook, they are making TikTok, they are making all sorts of platforms for speech. Imagine a world where everyone is held liable for the statements that they have made because it was negligently made. And because someone claims that because you made that statement, I relied on that statement and I have suffered economic loss. Or you said that this and this would happen. And because of that statement, I picked it up from your platform or from your website, or you told me so in person and I relied on it. And so I've suffered this economic loss, this financial loss. I went to buy shares in the company that you told me that the shares are quite great, but now they've fallen within 3 days and have suffered monumental loss of money. So the words are very easy. It's so easy to make speeches and to talk casually, but as against where you are talking about property damage, it's not so easy to have that kind of a loss spreading around. Then he also said, Lord Reed also noted that negligently made articles will cause only one damage. If a vehicle is not properly done or repaired or manufactured, it could only cause just one damage. And we find out that there is a problem with the vehicle or with the article or with the, whatever it is that is the item that we are talking about. But when it is a statement, the number of people that can be affected is so difficult to determine. It's so difficult to determine. So that is why we talk about the floodgates argument, so to say. Now, the general rule, general position in English law, the common law, is that negligent misrepresentation gives no cause of action in tort, where it is for pure economic loss, pure financial loss, like the instance that we had described earlier. And therefore, the implication of that is that the court was not ready to recognize that foreseeability of harm is sufficient. In fact, it's regarded as insufficient to grant liability. If it is foreseeability, it's likely to create the problem or the floodgates issue that we had talked about, because it can be reasonably foreseeable that, for instance, if I put a statement online on my website or on on Facebook, millions of people can see it's reasonably foreseeable that millions of people will see the statement, will read, and if they rely on it, they could be from the US to Australia to Nigeria to Canada to Ghana, and then you allow all these people to sue me because of the statement that turns out to have been negligently made. So foreseeability is not sufficient to grant liability, and that is why that was why the law was not prepared to allow a cause of action or a duty of care for negligent misstatement causing pure economic loss. When the case of L.A. Byrne against Hedley and Partners arose in 1964, it raised that question whether if you are negligent in performance of a non-contractual service causing pure economic loss, you could be held to a duty of care. It was a case where someone had sought for a reference, and when the reference was prepared by the defendants, it was negligently prepared, and the plaintiff relied on that reference to their detriment. Unfortunately for the plaintiffs, the defendants had put a caveat without prejudice. So despite the fact that this Elivine case, a locus classicus in this area, which you should be familiar with if you are discussing negligent misstatement, it is your key case. The case was unable to find defendants liable. But in that case, it is very significant that the court was able to find that there could be negligence, there could be duty of care for negligent misstatements that cause pure financial loss or economic loss by creating a new category of special relationship. It goes beyond reasonable foreseeability now, but that the court now said that there must be a special relationship, and it is a form of proximity beyond reasonable foreseeability in L.A. Byrne and Ella and Partners. The issue of reliance also came up, that there must have been reliance on the statement. The Elibine case is therefore recognizes and expanded the law of torts beyond saying that, oh, there is liability for deceit where statements are fraudulently made, as noted in Derry and Peake. It extended the frontiers of liability in the law of tort by recognizing the fact that there can be liability for negligent misstatements that cause pure financial or economic loss. The other lines of cases are in the slides, and which represent the fact that liability for negligent misstatements causing economic loss could exist. You can see the Nigerian case of the Marcel Chemical Company Limited against National Bank of Nigeria and Agomagbe Bank against CFAO. The early buying decision is important in many respects. Like I mentioned earlier, it's represented the emergence of liability in tort for statements that are negligently made and that cause pure economic loss. Don't forget the statement, I said pure economic loss, not just economic loss. If the economic loss is consequential on damage to property, you have hit my vehicle by your negligence, for instance, and I have to repair it, that's an economic loss, but is arising from a property damage. But we are talking of statements, for instance, where you rely on if an auditor's report, if an accounting report in making an investment decision, and that decision proves to be, detrimental to your business interest because it was negligently made. Then we are talking about pure financial loss. So Hedley, Bryan and Heller and partners of the case of 1964 expanded tort liability. And don't forget that we said that the categories of negligence are never closed. So there's always room for tort expansion to capture the needed realities of human existence. The Hedley decision also identified the basis of duty of care in negligent misstatements by holding that there must be a special relationship between the claimant and the defendant, derivative of a voluntary assumption of responsibility. And secondly, that there must be reasonable reliance by the claimant on that statement. And don't forget, we said these statements could be oral or they could be written. It does not really matter. The formulation of liability for negligent misstatements causing economic loss have been considered in a host of cases. All these cases before us are very important. The Hedley case that I had mentioned, Otto J. S. All and Co. against Simmons, Queen and Cognos Incorporated, Caparo Industries against Dickman, James McNaughton Paper Group Limited against Hikes and Anderson and Co. And we are going to be looking at some of these cases. Now, the rules are these: that a duty of care for negligent misstatements causing pure economic loss, a duty of care that is based on special relationship between the representor and the representee is expected. And Lord Reed said regarding this that there must be a misstatement, there must be a voluntary assumption of responsibility, and there must be a reliance. A misstatement, a voluntary assumption of responsibility, and a reliance. And in order to expatiate on this specifics, a duty of care is usually held where there is a special relationship by way of proximity between the parties. Of course, if there was a contract, for instance, between them, there will be a duty of care. If there was a fiduciary relationship, there will be a duty of care. But it has been recognized that where you give advice that is requested for purely on social occasions, where there is no relationship, it is not reasonably foreseeable that you would rely on that statement, and it will be expected that you seek further professional advice. I'm sure you have noticed that sometimes statements are made online on the internet and say, for instance, medical advice are given these days because we are in the information age, like I said, and they will tell you that it does not derogate from the need for you to seek proper medical advice from your doctor, so that they therefore point you in the direction that don't just rely on this statement that I'm making, but seek other advice that is more detailed. So where you give purely social occasion, the likelihood is there that the court would say that it's not foreseeable that plaintiff rely on the statement. You meet your friend at a party, for instance, and you over the cup of beer, you say, oh, what's your opinion about this or that? It's not likely that the court would feel that there is a duty of care in that context. But again, the facts of the cases are very, very significant. Where a non-professional gives advice on a purely business occasion, and he knows that the person being advised is going to rely on that statement, has financial interest in that statement, then there is likelihood to be a duty of care not to cause damage by being negligent. We've talked about Lord Reed speaking in Ellie Bryan and Ella and Partners that the defendant must have assumed responsibility. In this context, we must note that it is not necessary for the defendant to say, oh, I'm accepting responsibility for this statement, or you can take me to the court if I'm wrong or something, but that the context and circumstances of the case will make the court to assume that there is an assumption of responsibility. So it's an objective test, and the case context determines if responsibility has been assumed. Where was the statement made? To whom was it made? In what circumstances? Is it reasonable? Those are the factors that the court will consider and say, okay, we think that where in the light of these realities, you have assumed responsibility for the statements. And in Smith and Herrick Bush, Lord Griffith said the phrase assumption of responsibility can only have any real meaning if it is understood as referring to the circumstances in which the law will deem the maker of the statement to have assumed responsibility. So the circumstances are the law would hold that objectively, anyone who makes a statement in this context as assumed responsibility is what we mean by assumption of responsibility. Some cases have tried to explain these propositions of the law regarding the fact that there's a negligent statement and that it there is a sort of relationship between the parties and that there is reliance. Statement that was put on the website in the case of Patchet and Swimming Pool and Highlight Associates was held not to provide a duty of care to the person that relied on it. But you might wonder, okay, the website is available for everyone to access. What about if the statement was put on the website of a school, for instance, and students are supposed to visit the website and obtain information? You can see that that will provide a different context to a statement that is made on the website. So we have to get the facts of the case right and then be able to apply the rules. In Playboy Club versus London and then Banca Nacional de Lorovo Spahe, the court held that there was no liability where the person making the statement did not know that it would be communicated to the claimant, did not know that it will become communicated to the claimant. So that's another consideration. Who made the statement? Who would it be made to? If there was no reason for you to the representative to suspect that the claimant, the person that is suing now, would receive the statement as a form of advice, then liability will not arise. And that's Caparo and Industries against Dickman was a situation where shareholders were relying on audit reports to acquire a bank. And then the court said that, look, this audit report is generally circulated. And so it goes into the whole world. And you cannot allow everyone who relates to that statement, who relies on it, to bring a cause of action. And that these shareholders, they were existing shareholders of the company, by the way. And the statement of the auditors was not meant for the shareholders to acquire shares in the company. So it was not meant for them. And the purpose for which the statement was therefore made was different from the purpose for which it was utilized. So that's another consideration, apart from saying who made the statements and to whom and in what context. This context can be determined by the purpose of the statement. What was the reason why the statement was made? So this is another case, Mutual Life and Citizens Assurance against Evans, which also reflected the need for there to be proximity. And in this case, the defendant was required to have been in the business of giving advice. The assumption of responsibility, like I said, it's not direct assumption, but that the context of the case would determine whether responsibility has been assumed. In the case of James McNaughton Paper Group against the James McNaughton Paper Group, the submission of the law was made that in order to determine this proximity, which entitles you to a claim for negligent misstatement, for you to show that, oh, beyond reasonable foreseeability, there is proximity. That proximity is encapsulated as a special relationship and reasonable reliance. You must show, for instance, what is the purpose for which the statement was made. If it was made for purpose A and you used it for purpose B, you may not be able to show that there is that proximity. What is the purpose for which the statement was communicated to the person making the statement? What's the relationship between the advisor, the advisee, and any relevant third party? So the auditors who had written the audit report, for instance, would represent the advisors. The advisee, was it written for the existing shareholders, or was it written to the general public for anyone to pick up and say, okay, this company is doing well, and I'm going to buy shares in the company because of that audit report that I've seen. So if that is allowed, then anybody can just pick up that statement, line about, even on the floor of the road, and look at it, and you use that report to make some decisions, and then they come back and say, oh, I've relied on that statement. And I'm sure you know that that will create floodgates of litigation. So that is not likely to sell. The size of the class to which the advisee therefore belongs matters. If the advisee belongs to a very large and indeterminate class of people, it is of high probability that the courts would hold that there is no liability or there is no duty of care in that context. And then the court will also look at the state of knowledge of the advisor. Is he a professional, for instance, giving professional advice? And the court will, those are considerations that would likely, sway the court to hold that there's a duty of care. So who is the person making the statement? What's the statement of knowledge of that person? What is the expertise that is displaying or he has acquired? Okay, these are some of the considerations that assist the courts. If the advice is paid for instance, if you have paid for it, there's the likelihood that the court would hold that there is liability, although there is a duty of care when there is a negligent misstatement. It was also be demonstrated as shown in the case of James McNaughton Group, that the advisee, the claimant or the plaintiff in the course of action relied on the statement. And the reliance, it must be a reasonable reliance. Is it reasonable, for instance, to meet a stranger on the road and ask for advice about a car or something, and then you just proceed without even knowing who the person is, and you act on it and say, oh, because he advised me, I relied on it. In summary, therefore, common law has streams of liability for statements. There could be liability for fraudulent statements called the tort of deceit. If there is a contractual relationship between the plaintiff and the defendant, it can be a breach of contract where the statement is negligently made. If there is a fiduciary relationship, especially when you have situations of professional relationship, a lawyer and the client, and the doctor and patient, and what have you, then statements that are made in that relationship could create a duty of care. But there is no liability for there was no liability for negligent misstatements causing pure economic loss under the common law of tort. There was no liability for negligent misstatement causing pure economic loss. The liability for negligent misstatement causing personal injury was the first stage in tort liability for negligent misstatement. If the statement was negligently made and the person suffered personal injury, for example, you have given an advice about a building construction, or you are giving advice about medical advice, or any kind of advice, for instance, or any kind of statement that causes personal injury, the liability was recognized as a first stage of liability for statements. But statements that caused pure economic loss that are not contingent on property damage, were not recognized. The policy considerations have been examined. The danger of liability to an indeterminate group over indeterminate time and for indeterminate loss. And the first recognition of liability was in the case of Byrne and Hedley Partners. Don't forget that I said in that case that defendants were not held liable because they had entered a caveat, so to say, against their liability. Otherwise, they would have been liable. And the court formulated that there liability, and there is now liability for negligent misstatements causing pure economic loss, even in the absence of contract. On this basis, many professional as statements that have been negligently made have been judicially considered in the cases that are in our presentation. Bankers, accountants, solicitors preparing statements for clients, all sorts of professional statements have been brought before the courts, and these have been perused against in the light of the principle laid down in the line of cases that Byrne and Hedley partners commenced. The rules of liability continue to emphasize the need for primate relationship and to exclude relationships of indeterminate grade that may result in unlimited scope. So if there's likelihood of an indeterminate number of people coming to sue because of that statement, then the court will limit the duty of care in that circumstance. In summary, therefore, the case of McNaughton Paper Group against Hikes created that, brought out the factors of liability for negligent misstatements, what is the purpose for which the statement was made, and what was the purpose for which it was used. Who was it communicated to? And did you know that that statement will be communicated to that person? So if you were giving the statement for the use of A, and A gives it to B, or B comes across it and relies on it, it is likely that there will be no liability. What is the relationship between the parties, maybe the plaintiff and the defendant, and any third party to whom the statement is made? What is the size of the people to whom the statement is made? If you make a statement to the whole world, and it's not very unlikely that the whole world will be allowed to sue you. So that will weigh in the mind of the court in determining the scope of liability. What is the state of existing knowledge in the society that would inform whether this statement was made in the right context? And then the courts expect you. It's not sufficient to come to court to say that there is negligent misstatements and that this negligent misstatement has created a form of proximity because it has met the needs as stipulated in the courts, just as discussed now. You must also show that there is reasonable reliance, that your reliance on the statement was reasonable. Not that the statement itself was reasonable, but that it was reasonable for you to rely on the statement. So if it's not reasonable, if the facts of the case do not show that it is reasonable to rely on the statement, then you may not be able to claim the state a duty of care was owed to you for that statement that was negligently made, which has caused you pure economic loss. Don't forget, we kept saying pure economic loss. So these are the rules relating to negligent misstatements causing pure economic loss in the law of tort. I hope to see you at the next presentation where we consider other issues of law in this respect. Please don't forget once again to subscribe to the Law Professor channel.